Welcome to Breaking Bank 8, Memorial Day weekend edition. I'm not going to be grilling or anything, but I thought it was appropriate to meet in a park since I've been homeless most of the last 8 years, fighting for your freedom. I'm the only human being that's been memorialized, that has a memorial in my name on Facebook, or had it. I had it removed. It said Remembering Jack McKeag. Why is that? Facebook created a death certificate, a notarized death certificate, even while I was alive, right? And that is a death threat by Facebook, where it says Remembering Jack McKeag. You all saw that, and I'm going to show photos of it here for other people. I've opened up Liberty Aid again, libertyaid.org. It's the only proven method for debt removal in the USA plantation, and I was given a death threat on Facebook because of it. So think of all the trillions of dollars that is spent on war. All that war was fought for one single reason, and one reason only: to install private central banks and then remove the assets that people own and devalue the money that you have and devalue the assets you have. Trillions of dollars spent on enslaving you. And I've gotten a couple $1,000s in donations over the years of fighting the bankers successfully. I've heard of millions of dollars of debt being removed by people. A $250,000 mortgage was removed recently. Anytime anyone has removed any debt, I've never gotten a donation after they've removed their debt. No one has donated. Not a single individual has been like, thanks for removing my debt, and donated a penny after they did it. No one. So, but I'm still fighting for your freedom, but some donations would allow me to, not be homeless. So I'm glad you all are keeping your homes. I don't have one, but I'm glad that you are in a home. I'm a Christian minister. I operate under the Christian Ministries Trust. It's common law, irrevocable ecclesiastical trust, and I'm under God's authority, Jesus Christ, Meribaba, who was the same individual. So now I'm going to give you information in this episode. So please consider donating, please. I'm the only warrior fighting for your freedom against the banks, and I can prove it. I've been memorialized this Memorial Day weekend, so please consider donating. So there are 3 court cases in Sarasota County right now. 2 are FDCPA violations, one's an FCRA violation. And this is, 3 separate motions for summary judgment. The exhibits are the same, and the summary judgment is actually pretty much the same, except for the name of the defendant in each one. And like I said, 2 were Fair Debt Collection Practices Act, FDCPA violation. One is Fair Credit Reporting Act violation, FCRA violation. And I'll probably be starting another one of them too. See, 2 separate companies say that they're the same company and that I owe them the debt. Not one of them. They say I owe them both and that they're the same company. Let's go through my answer to what they had to say. They came to court. Some of you have seen the video that Ashley Gee posted, and I appreciate her filming that. What they did was take a counterfeit note, a copy, and they called it a copy. It was a so-called copy. It wasn't a copy of anything. And then they had a so-called copy of a license that was 5 years out of date, proving the relationship between these 2 businesses. A 5-year out of date license, a copy of one, so-called copy. And so the judge took those 2 things and removed my ability to go to trial. I can't go to trial on the FDCPA violations. They removed it. They said, oh, you have to go to arbitration based on, this so-called copy. of a promissory note. So let's go through what I have to say about that, because I think it'll be informative to everyone. So there are three separate cases. I'll show you one right here, and then I'll go through, see, it's against World Omni Financial. That's the one on the credit report of the person. So let's go through this. Plaintiff John McCaig, motion for summary judgment. This will be a long video, but I think you'll get a lot out of it. Plaintiff John McCaig. Plaintiff hereby moves to compel summary judgment against defendant, Southeast Toyota Finance. Looks like I have a typo in there. Let's go through the one that is, I know is 100% accurate. This is the first time I've written a motion. Here it is, right here. And that's the FDCPA violation right there in the judge. So let's go through this one. But you can see this one right here. And here's who, John McCaig, plaintiff versus Southeast Toyota Finance. Plaintiff John McCaig, motion for summary judgment. All right. Plaintiff John McCaig hereby moves to compel summary judgment against defendant, Southeast Toyota Finance defendant, in the case due to the fact that the only evidence presented was a counterfeit note and a copy of an outdated license to do business. Also, since the court appearance, representative for defendant, Richard Martin, has engaged in domestic terrorism against plaintiff, using threats about Facebook postings where plaintiff was recently given a death threat by Facebook for his work as a Christian minister. In addition, defendant counsel Richard Martin has engaged in a felony for admitting a counterfeit note into the court record and should face criminal indictment for his actions by the state of Florida, since it was done before a judge. In support of this motion, plaintiff states as follows. Introduction. At the only appearance for case number 2016 SC 002128 NC, defendant's attorney presented a counterfeit note that the court accepted on record. See Exhibit A attached, and made a ruling compelling arbitration. See Exhibit B attached. So let's see Exhibit A. Defendant's attorney presented a counterfeit note that the court accepted on record. See Exhibit A. All right, let's go to Exhibit A. Exhibit A. See, he put in a motion here that was accepted to compel arbitration, right? And this compelling of arbitration, he said that World Omni and Southeast Toyota Finance were the same business. And then he took out arbitration. Let's go. Then he took out the arbitration clause from this counterfeit note. There we go. Here's his motion. And more motion of his. And more motion of his. And this is the exhibit that, this is what he came up with here, his Exhibit A, right? This is a copy only. No original was produced in that courtroom. This is a copy of a note. And so that's a counterfeit note because no original was presented. So it's a counterfeit. All right. So that's what he presented. Now let's go back through here. That's Exhibit A. And I was talking about bugs. Compelling arbitration. See Exhibit B attached, where she compelled arbitration, the judge did. This is my Exhibit B, right here. And this is where, see, John McCagg versus Southeast Toyota Finance on case number, right? And then court compels arbitration. See it? Right there. And she signed it. This is her compelling arbitration based on copy of a note. No original. I'm going back to my. The bugs are getting me. Hold on a sec. Ugh. There's no seams. So let's go back to my motion. No original of the note was presented. It was not shown to be a copy of anything. See Exhibit C attached. My Exhibit C. This is explaining, this is United States Code, Title 15, Chapter 41, Subchapter 5. This is validation of debts, okay? This is part of the Fair Debt Collection Practices Act, which is part of the United States Code. And it says that it must be validated, which it wasn't. A copy was presented, not an original. So, let's see. At presentment of note, May 17, 2016, and when the note was put on record, see Exhibit A, that's the copy of the note that was brought. The note was not an original document, so no validation occurred. See Exhibit O. Oh, that's just a typo. So I've got some typos in here. Ugh. Anyway, that's meant to say Exhibit C. Anyway, it's about the Fair Debt Collection Practices Act. Like I said, God, the no seams. This is my first time I've written a motion, so there are a few errors in it, but I'm pointing them out as I go. In addition, another document was produced by defendant attorney Richard Martin, said to be a copy, again with no original, of the licensed Southeast Toyota Finance for them to operate under said name as a DBA, doing business as. That's what DBA means, in case you don't know that. Doing business as. World Omni Finance. See Exhibit D attached. Let's go to Exhibit D. Here's Exhibit D. Exhibit D. He presented this document for Southeast Toyota Finance. See it? It's a license for a fictitious name, but you notice the date on it will expire on 12/31/11. This is a 5-year out of date so-called copy of a license that the judge accepted. Unbelievable. Talk about a miscarriage of justice. Okay, so plaintiff was requested validation of the alleged loan on several occasions, and when presented with a copy, no originals were ever offered to be viewed, though it was what constitutes proof of debt. It's Exhibit C, that's a validation in the United States Code under Fair Debt Collection Practices Act. The plaintiff paid off copy of the alleged loan with copies of a postal money order and acceptance of the change of laws to allowing copies of proof of debt by defendants. See Exhibits E, F, H, and I. I sent letters. If you can look in my other videos, but where I showed I sent validation letters to them. Here are those exhibits of the validation letters. Exhibit E, I sent it, they got it. Here's what the validation letter looks like. I sent them on these dates. Exhibit F that was sent. These are different validation letters that were sent, right? All it is requesting, could you please let me look at the original note? It's not saying I don't want to pay. It's saying, please show me proof that I need to pay. That's all it is. All right. I'm not going to show you H and I yet, but I'll get to that. But let's get to the next part of this. Response by defendants, Exhibit G, in which a counterfeit note was sent. A so-called copy of a promissory note, no original was mentioned as viewable, though that is what was requested. Either an original must be presented to prove a debt, see Exhibit C, or the defendant's copy is accepted and copies can be used for debt instruments, which in case was paid in full by plaintiff's copy of money order sent, see Exhibit H. Okay, so Exhibit G, this is what they sent me. Oh, here you go, blah, blah, blah. And thanks for contacting us. And then they sent me a copy. They didn't say come see the original at any point. God, these no-see-ums are killing me. So what I did was I sent them a letter back. Said, fine, the copies are fine. No problem. Thanks for, clearing up the standard of validation that are acceptable to you when you send a copy of a debt instrument. Promissory note, you called a copy without the ability to view the original. I intend to raise the standards in the copies of the debt instrument that I sent you and the original note. See copy of the court case attached. Okay. But what I did is, if you can read the rest of this on your own. But what I did was I sent them a copy of postal money order. And I sent them, see, that's a copy. And I sent them enough copies. Here's page after page of the copies, right? Enough to pay off the amount. They sent me a copy of a note, so I sent them copies of notes in return. I also told them, what they'll be getting in a lawsuit if they don't say it's paid in full on the credit report, which they did. See, here's the thing. They send me, this bill in the mail. They have to validate it. They didn't. What they did is send me a copy, right? Here's all the laws saying, what they have to do. CFPB, they oversee the Fair Debt Collection Practices Act. They say that banks are debt collectors. All right. So see, what happened is they sent me a copy of a note. They showed up in court with a copy of a note, but I already paid it with copies of a postal money order. So that should have removed the debt. If they're saying copies is fine, which is against the law, it's like making a copy of a dollar bill. That's counterfeiting. If you come with a copy, we'll get into the exact law they broke. Since the court appearance on May 17th, defendant attorney has made a threat to plaintiff, see Exhibit J, about a Facebook post. Let's see. Look at this. Exhibit J. About a Facebook post. Writes the judge and says, hey, look, he made a Facebook post. What was the Facebook post? I posted someone else's YouTube video of my courtroom appearance. So that was another threat I got. It's illegal. He's threatening to say it's illegal to post somebody else's YouTube video. Unbelievable. I didn't make a video. Since the court appearance, okay. Since clearly the defendant's attorney Richard Martin follows plaintiff on Facebook, he understands the plaintiff was given a death threat by Facebook by memorializing his count. See Exhibit K. Exhibit K. Exhibit K. Here's what I wrote about this. You can read it. This is what I said to Facebook. They owe me $1 million. And here's proof of it right here, see? Remembering. And took a lot of photos of it. Remembering. See, that means a death threat by Facebook. So clearly him threatening me is adding to the death threat on Facebook. He's adding to the threat. Facebook engaged in domestic terrorism against me, against against the person, and now defendant's attorney Richard Martin has added fuel to the fire by cyber-stalking plaintiff and harming and injuring him by adding threats to plaintiff about Facebook, and is possibly engaged and colluding with Facebook in domestic terrorism. See Exhibit L. It's a definition of domestic terrorism. United States Code on Domestic Terrorism, which it fits the definition of. Defendant attorney Richard Martin should be arrested and disbarred for these threats and for his counterfeiting of note. Since evidence was presented to the court in both these matters, the judge is compelled by the oath to the citizens of Florida to take legal action against these criminal activities. In short, plaintiff was simply asked time and time again for validation of the loan, and no evidence of the debt was ever presented. Since no evidence exists of the debt, defendant hired the largest law firm in Florida, which is Ackerman, LLP, to threaten, harm, injure, and terrorize plaintiff, who is a Christian minister. Since most attorneys are Freemasons and all Freemasons worship the devil, it begs the question, is this a combined action of satanic terrorism against the religious freedom of the plaintiff? With this overwhelming evidence, it compels the court to use the court's power to force the plaintiff to remove this item from the credit report of the plaintiff, to make the defendant produce the title to the vehicle and sign it over to Christian Ministries Trust, and compels the court to investigate the attorney Richard Martin and his firm Ackerman LLP for their domestic terrorism and felonious activities, and to seek disbarment of Richard Martin from practicing law. Introduction. Defendant used a counterfeit note in their motion and should be arrested and disbarred for this felonious action. As set forth above, defendant's attorney Richard Martin entered into the record a motion with the counterfeit note. I already showed you that in Exhibit A. No original of the note was presented in court. The plaintiff brought up that need to be original. The judge accepted the counterfeit note and moved for arbitration. It's Exhibit B. That was the arbitration ruling. All promissories don't need to be in original form or they are counterfeit, according to the FDCPA and Exhibit C. Under Florida Statute 831.08, quote, possessing certain forged notes, see, this is a forged note, it's a counterfeit, bills, checks, or drafts, whoever has in his or her possession 10 or more similar false created bills, etc., commits a felony of the third degree. So there's a law that says you can't have counterfeit notes, and then it's a third degree felony. All notes must be in original form, not a copy. If copies of notes could be used, then anyone could use copies of Federal Reserve notes for purchases. Using copies of Federal Reserve notes is called counterfeiting, and so is the presentation of another non-original note. Richard Martin should be arrested for his third-degree felony and disbarred for his illegal activity. Since the judge in the case took a counterfeit note into the court record, the County of Sarasota Corporation can be held liable for being in possession of this note. This is a formal request for the bond and insurance information for Judge Erica N. Quartermain of the County of Sarasota Corporation, in place during the incident on May 17, 2016. So remedy can be sought since due process of law through the courts was removed by granting arbitration using a counterfeit note. So I hope you understand what that says. You know, you can get remedy after court if the judge does something illegal. There's bonds and insurance in place usually to get remedy after an illegal activity by an employee, a government employee. And that's what this is a government employee doing something illegal. If Judge Erica Quartermain is a public servant, it is requested that the laws of identifying a public servant be adhered to, and she fill out the public servant's questionnaire. It's Exhibit M. So remedy can be sought since legal remedy in the court system was removed from plaintiff based on a counterfeit note. Exhibit M. I haven't shown you that one. Exhibit M. This is a public servant questionnaire, and it shows that they have to give me this information so I can seek remedy against them. See, they have to identify themselves. They ask for your identification, right? Here are the laws. They ask for identification. They have to identify themselves as a public servant. Let's get on to the next part of the motion. As set forth above, defendant presented a 5-year out-of-date so-called copy of a license proving there is no legal relationship between, they proved it, right? Between defendant and World Omni Financial Corp. See Exhibit D. In spite of the defendant attorney Richard Martin entering this out-of-date so-called copy with no original of the copy presented, Judge Erica Quartermain ruled that there was a relationship between the two entities because they were represented by the same counsel in both cases. The judge said it was in the interest of saving counsel time, even though no law was shown that allows for this activity of binding two cases together based on attorney's timeliness. The fact that defendant's attorney Richard Martin entered into evidence what proved that no relationship exists was overruled by the judge in favor of the better enjoyment of attorney timeliness, despite plaintiff's objections. Based on a counterfeit note and a so-called copy of a 5-year out-of-date license, Judge Erica Quartermain eliminated due process of law and forced plaintiff into arbitration for no legal reason. C. Defendant As set forth above, defendant was sent validation letters in an attempt to see if the debt they were billing was legally due. Those are my validation letters again. Response from the defendant dated 11/10/25. See Exhibit G. I already showed you that. In which a counterfeit note was presented as proof, as a so-called copy, and no original of the promissory note was mentioned as viewable, nor was it brought to court on May 17, 2016. They sent a copy, okay, but they didn't bring an original to court. You have to bring an original. Otherwise, only a counterfeit promissory note was brought to court on May 17, 2016 by defendant counsel Richard Martin, which was accepted into evidence. The terms of the defendant's response to Exhibit G of using a copy of a debt instrument were accepted, and copies of a debt instrument were sent that totally paid off alleged debt. See Exhibit H. See, they sent a copy, so I sent as copy the postal money orders. Defendant cannot have it both ways. Either a copy of a debt instrument is acceptable, though illegal, and the debt was paid off, see Exhibit H, or the law must be followed, see Exhibit C, which is that it has to be original. And an original of the promissory note must be presented, and no original of the note has been presented in court on May 17, 2016. Logic dictates that something is not a copy of anything unless the original is presented next to the copy at the same moment. A presentment of note on May 17, 2016, and when note was put on the court records, Exhibit A, the note was not an original document, so no validation occurred. See Exhibit C, was made as set forth by the FDCPA and FCRA, United States Code. The opportunity for this presentment of debt instrument as validation was on May 17th, but no original was presented next to the so-called copy, thus making the copy a counterfeit. Has defendant lost the note? Where are the lost note UCC filings? When did they lose the note? Was the UCC filing made within the required 30 days of loss? See, if you lose a note, you have to, file and say, I lost the note. And then it has to be, well, when did you lose it? And you have 30 days to file. I didn't see any of that filing in court. Why does the website of World Omni Finance say it sells these notes? How can it own notes it has already sold? Plaintiff is but one of thousands of victims of defendant in an obvious scheme of fraud to steal hundreds of millions in equities that has already been sold. The court has the documents that prove not just one case of counterfeiting, but defendant's documents also prove that defendant is operating a scheme of fraud in collusion with auditors, attorneys, and sellers of public offerings. The court is compelled to get in touch with the SEC, Treasury Department, Homeland Security, FBI, Florida State Police, and sheriffs in proper jurisdictions to shut down this illegal Ponzi scheme, of which plaintiff is just one of thousands of victims. Despite this concerted attack against plaintiff by defendant, a settlement agreement was preferred to defendant's attorney Richard Martin. See Exhibit N. I did give them a settlement attorney. Here's Exhibit N. I did give them a settlement agreement, a settlement offer, I'm sorry. Just really, it's forgiving them and saying, hey, I forgive you from your sins of working for the devil. I forgive you. Please just give the title to the Christian Ministries Trust. I work to help the homeless. I am homeless. I have been homeless on many occasions for the past 8 years, when my home was stolen from me in a foreclosure in 2008. So that's why I fight for you. Please consider, giving a donation to Christian Ministries Trust. I'm the only memorialized, the only memorialized human fighting against the bankers and giving you proof of how to beat the bankers. I made some errors, some minor errors in this motion I've noticed as I've shown it to you, but hopefully they accept it. If not, they'll have to answer these 100 pages or so of truth, and I'll just produce more truth and produce more videos and show you how to get out of debt more and more. Really, they haven't killed me. They can't kill me. I know they want to kill me. I know they're discussing killing me. I know that's what these satanic, signed in blood to Satan attorneys, judges, I know that's what they do. And these bankers, they're stealing everything that we own. They steal our homes. They steal our cars. They have copies of notes, they're not valid, okay? That's just proof that they're doing it illegally. Anyway, I brought up using MMS drops before to get rid of demonic possession and disease. You can look up MMS Dr. Humble on YouTube and see that it's true. See, I don't live in fear. They train us to live in fear. Don't get me wrong, I was trained just like you to live in fear, but I take these drops and it gets rid of this demonic possession that we all have. They have all put demons in us. So please consider contributing to Liberty Aid so I can continue this work. I hope you're having a happy Memorial Day. God bless you. Breaking Bank, number 8.